Will former President Trump actually be barred from the Colorado primary? An unprecedented ruling by Colorado's Supreme Court is prompting reaction from other presidential candidates. Joining us now live is NTD's White House correspondent Iris Tao. So good evening, Iris. First, if you could break it down for us, what happens next as Trump is promising a swift appeal?
Good evening to you, Steve. You're right. Trump's team is saying that they have full confidence that the U.S. Supreme Court will quickly overturn the ruling by the Colorado Supreme Court, which says that former President Trump is disqualified from appearing on the ballot in that state because he had participated in an insurrection. Meanwhile, it's important to note that the Colorado Supreme Court itself put a hold on its action on its order pending any appeal action by January 4th. The deadline for the Colorado Secretary of State to actually certify all the candidates on the ballot is January 5th. So that means that unless the Supreme Court actually rules to remove Trump from the ballot by then, it basically means that Trump will still appear on that ballot despite the ruling yesterday. Steve.
So, Iris, given the fact that Trump lost Colorado in 2020 by about 16 points, he most likely wouldn't need that state to win in 2024. But the question remains, what if other states follow suit?
That's a great question. So the Lieutenant Governor of California today, citing the Colorado ruling, asked its Secretary of State in California to, quote, explore every legal option to remove Trump from California's 2024 primary ballot. But it's important to note that basically similar legal challenges trying to remove Trump from the ballots have been ongoing in basically half of the states across the country, and none has really succeeded up until the Colorado one yesterday. Steve.
And so how are other presidential candidates reacting to this ruling? Is there anything that stood out to you?
So all Republican presidential candidates, and that include Ron DeSantis, Nikki Haley, and others, and in addition to that would be independent candidate RFK Jr., have all come out to denounce the ruling, saying that it should be the voters to make that decision, not a state court. Basically, but however, in addition to the Republican ones, Vivek Ramaswamy among them is vowing to actually remove himself from the primary ballot in Colorado and calling on others to do the same. Let's take a look.
And I demand that Ron DeSantis and Chris Christie and Nikki Haley do the same thing, or else these Republicans are simply complicit.
Meanwhile, President Biden here at the White House, while saying that he won't get into the specific ruling itself, and said this today about Trump. Watch.
You saw it all. Now, whether the 14th Amendment applies, I'll let the court make that decision. But he certainly supported an insurrection. And no question about it. None. Zero.
Meanwhile, the Colorado Republican Party announced today that if that ruling stands, it would consider ditching the primary ballot system and instead switch to the caucus system, which will let them bypass the ballot issue here. Steve.
NTD's White House correspondent Iris Tao reporting for us live from the White House. Iris, thank you. The Colorado Supreme Court's 4-3 ruling to disqualify former President Trump from the state's primary ballot is calling the due process question into question here. Joining us now to talk about it further in the court's ruling and the implications is former U.S. Assistant Attorney General Jeffrey Clark. Jeff Clark, thank you so much for joining.
Well, it's great to be here, Steve, as always.
Thank you, Jeff. So, Jeff, in a 4-3 decision, the Colorado Supreme Court disqualifying President Trump from the ballot in that state based on its interpretation of Section 3 of the 14th Amendment and allegations that he engaged in insurrection and rebellion, as it states, against the United States. The court stayed its own opinion until January 4th of next year, presumably because it expects an appeal from President Trump to the U.S. Supreme Court. Notably, President Trump has not been charged with, let alone convicted of insurrection. Do you believe the Supreme Court of the United States will hear this case and ultimately reverse it?
So they should, and they may actually wind up dismissing this case, Steve, as moot just by virtue of the fact that cert is granted. Because The stay that the Colorado Supreme Court entered is the most unique stay I've ever seen. It doesn't just expire on January 4th, and I think we're told by Jenna Griswold that, by January 5th, she needs to know whether Trump's going to be on the primary ballot or not, so they can go through the administrative steps and print up the ballots, et cetera. But what it did was it said that a stay will last until January 4th, but if President Trump seeks review by the Supreme Court, then the stay continues until the Supreme Court enters an order. Well, if that takes you past January 5th, and that means President Trump goes on the ballot, you can see the Supreme Court basically saying, what's there for us to decide? He's on the ballot. And so it's a very peculiar thing. Like, was it just designed essentially to kind of force President Trump to seek cert and force to basically put this on the political agenda to try to, just continue a process of lawfare?
Jeff, you've previously written extensively that Section 3 of the 14th Amendment does not apply to President Trump, or any president for that matter, but only to an elector of president. You've also written that the president doesn't fall under the broader terms, hold any office under the United States. So with regard to this, could you kind of break this down and kind of show us how you came to this conclusion?
Sure. So, look, there was a senator at the time the 14th Amendment was being considered for passage by Congress, before it went up to the ratification process, and that senator sort of spotted that the president was absent from the list. So this is actually, a question that's more than a century old, and it's pretty obvious when you look at the structure of the provision that the president is absent from the list, and I think that was deliberate. The list starts in a hierarchy. It's first senators, then representatives, then electors for president or vice president, right? And then it's any other officers. And I'll dazzle you with a little bit of Latin here. There are two related canons of interpretation. One is called Noscitur Associus, that words are known by the company they keep. And then there's another canon, Iustem Generis, sort of a like kind. And they both would lead you to conclude here that if you have a list like this, right, it's not literally any other officer. It's any other officer sort of as a result of this hierarchical structure, which would mean officers that are inferior to the president. If they had meant to put the president on the list, they would have put the president and vice president on the list, and they wouldn't have put only the electors of president and vice president on the list. So it's actually a very basic legal form of reasoning. Anyone who had taken statutory construction in law school would recognize this argument. But, in the mainstream, like CNN, the mainstream left and MSNBC, they pretend it's some kind of hyper-technical argument. It's really not. They're deceiving their viewers.
Do you think that the timing of this Colorado court's ruling could be somewhat vindictive?
There is no man in human history, or even modern history, if you count lawfare as a modern development, who has ever experienced as much lawfare, or those affiliated with him in some way experiencing derivative lawfare, than President Donald Trump. So it's it's remarkable, but it shows their level of fear. They do not want him to return to office because they know he will be immensely popular. They know that he will turn things around, and it could be the kind of thing that, breaks the back of the Democrat Party for a very long time. So, they have an operation of get Trump on 100 different levels: federal, state, local, you name it.
But it also disenfranchises voters who ultimately decide who the president should be. So what legal remedy, if any, do voters have in this case? And could Colorado voters file their own appeal to the U.S. Supreme Court, or file an amicus brief to appeal Trump?
Yes, they certainly could file an amicus brief. I mean, we saw what happened in 2020 with all of the suits that a lot of them were dismissed for lack of standing. So they may try that maneuver to keep actual voters out. But we need to defend democracy. I think President Trump will obviously carry the torch for this. This is a massive denial of due process. The most fundamental way and easiest way to see that is President Trump has not been convicted by a criminal jury unanimously of insurrection.
Jeff Clark, really appreciate your perspective. Thank you for joining us.
Thank you, Steve.
And coming up, House Judiciary Chair Jim Jordan escalating his probe into the Department of Justice, issuing a subpoena to the Attorney General. Jordan is digging for information about the department's alleged collection of personal data on congressional staff. And U.S. Senate candidate Kari Lake saying she'll push America First policy, shore up support for her state and President Trump in the Senate, and secure the border. Thank you for watching the Capitol Report. If you want to see our full broadcast, check us out at epochtv.com.